So similar to a VA process, the director works with the restructuring practitioner, small business restructuring practitioner, to put a proposal to creditors and hopefully voted upon. And as you say, the ATO is going to be potentially a significant creditor whose vote will count in that process. And yeah, what else can we add to that?
I think it's important to add there that the votes in this situation won't include related party creditors.
Perfect.
So I know that what we see a lot of the time is that, yes, the tax office, has a significant debt in most small business insolvencies, but also there's generally a number of related party debts as well, whether that's money that the director has loaned into the company or that hasn't taken, as far as sort of unpaid wages and these sorts of things. Or other related party debts that come in to that to the company's creditors, they won't be allowed to vote in this structure. So that's why the understanding of what the tax office is going to do and trade creditors, that's really important, I think.
Yeah, and one of the key motivations behind that, from my understanding, is to ensure or try to mitigate the risk of illegal financing activity. And having small businesses, any company directors try to abuse this system and this reform. So again, we need to watch this space a little bit, and perhaps we can come back and give us sort of a tighter rundown once we have those regulations, and we can actually talk about exactly how it's going to look and how it's going to play out.
I think it's an exciting time, and yes, absolutely watch this space.
Excellent. Okay, so should we move on?
I thought that was quite good. How long did that go for?
Yeah, I think that was 10 minutes, which is why I sort of thought, okay, well, let's wrap it. So I think that's probably the limit.
Yeah, I think so.
Yeah.
Especially when you're bookending it with stuff.
Yeah.
You know what? I've got to do 5 minutes on. I've got the Brisbane Small Business Directory Group, who, like, they're a Facebook group and stuff, but we're on there. Anyway, it's next Thursday, 5 minutes. I've got
5 minutes.
Insolvency law reform in 5 minutes.
That's not long. It's no chit chat. Just get straight into it.
The law is changing. That's what I think is going to be my the end.
Oh my gosh, that's so funny. Okay. So,
all right. Next. Do you want to have a talk? You didn't really get a chance to go through a lot of your stakeholder stuff last time. Do you want to talk about that?
No, I didn't. Did I?
No, I'm just thinking, I'm happy to sort of ask the questions and you can have a...
I'm actually just trying to remember. It feels like so long ago.
Have you got it? I've got it in front
of me. I'm looking at it right now. I'm like, wait a minute, what's going on here? Oh, yeah. So maybe we could just do a little bit about... Well, why don't we do a little bit about those key stakeholders?
Yeah.
So was that in relation to the simplified liquidation, or was that the...
I thought it was in relation to how the new models may affect company stakeholders. Okay. Well, why don't we do... It doesn't really need to be in any particular order, and then we can do...
that's right.
Simplified. Do you know what I mean? So then they'll...
Because I assume there'll be timing on the recording. So I can say to Tamara, between this one and this one, we're talking about X. Between that minute and that minute, we're talking about Y.
Yeah.
She'll just like divvy it up for us.
Yeah, I reckon that's it. Gotta love it. No, that's right.
All right. So let's just have a look. Let me make sure I get my... So, okay, well, let's just go into it. Let's talk about the impact that these proposed reforms are going to have on the various company stakeholders. And by that, I mean directors, creditors, employees, liquidators as well. We can't forget our friendly liquidators. So perhaps we can break it down and look at those various stakeholders and the two primary aspects of the reforms, which is the debtor in possession model and the simplified procedures for a liquidation.
That's right.
So most of what we know comes from the fact sheet, which was released, and of course the bill, and we're still waiting on those regulations. Some of the takeaways really, the real takeaways is how it impacts directors and office holders, who they're the decision makers in terms of the debtor in possession model. And the director remains the decision maker during the restructuring process, which is a huge difference from the current 5.3A provisions in the Corporations Act.
Absolutely. I was just going to say, and I think it's really important, a lot of the commentary that I've heard recently is that certain groups are worried that directors will be sort of not coerced, but sort of recommended to go into these restructuring regimes without fully understanding the implications that it might have for them and the business. Because obviously wanting to restructure is one thing, but putting the company into a formal regime to restructure is a little bit different. And I don't know, Stacey, do you know sort of some of the more pertinent implications that might be for the companies in this regard?
Yeah, well, I mean, there's lots of positives. The key negative, and perhaps we, as advisors, we have to make sure we're educating our small business clients, our individual office holders and stakeholders about what the effect of this is. So directors need to know that proposing a restructuring plan is in fact an act of insolvency. So that's going to come under the new Section 455 capital A. So it's similar to, for those familiar with Part 9 in the Bankruptcy Act, it's the same as an individual executing what we call a Section 188 authority and putting forward a personal insolvency agreement. So the director, by proposing one of these restructuring plans, has actually triggered an insolvency event for the company. Now, presumably, there's a balancing act when it comes to whether or not he should or she should or shouldn't do that. And it's likely that the company is in financial distress and possibly insolvent already. But that's something that needs to be explained, because if the restructuring plan doesn't get voted up, or the debtor in possession model doesn't get voted up by creditors, the proposal under that model, then there's ramifications for the company and the director after that process. It may then be pushed forward into liquidation, or there might be trading insolvent claims down the track. And the fact of this event back then may in fact make it a little bit easier for a registered liquidator to pursue those voidable transactions under the Corporations Act. But I think there's more benefit to directors than, so more positives than negatives when we're looking at this process, because one of the hardest things for directors, I find, when I'm advising them, is that handing over of control to a voluntary administrator under the Corporations Act. So this model, which is going to be available for those companies with less than $1 million in liabilities, is going to have that benefit of the director remaining in control, able to continue to trade, able to deal with both creditors and debtors of the company, and retain his or her position at the mast of the ship, so to speak. So that's something that's going to be really attractive to directors when they understand that, and I think that's going to be, I see that increasing the potential utilisation of these reforms. They do need to be advised about the unavailability of those voidable transaction recoveries in the Corporations Act if we go through that simplified liquidation process, and also if there's a restructuring proposal which is accepted by creditors as well. The other potential significant benefit to the directors of these smaller entities is the ability to minimise costs. There's a lot of negative publicity. I'm sure you get hit with it frequently.
Very frequently.
Fees and remuneration and the cost of these liquidations. And it really, I mean, when you're in the industry, we see it, we know what's involved in advising on various aspects of a liquidation or a voluntary administration. We can see legal fees go up. We understand how much time and energy is put in by all the professionals. But to your general public, that lack of information or understanding, and I say that in a very respectful way, about all the processes, leads to a real disconnect for them between the level of fees that are incurred and the actual size of the administration. So these reforms present the opportunity to adopt either simplified liquidation procedures or to pursue a restructuring proposal where the director retains some control throughout the process. And I think from a psychological perspective, that is going to be something that means a lot to a lot of small businesses.
It's only something they can use once, isn't it, though, every 7 years or so? So it's sort of, we need to be careful, I think, directors, when they're entering into that arrangement, to understand that this isn't sort of a get out of jail free card.
Yeah, absolutely.
The next time it happens as well.
And 7 years is a long time. I mean, if you're a director of a number of entities that are related, you might have different arms to your business. You might have a trading entity, you might have an asset holding entity. Often the case is that the collapse of one will affect the ability of the others to keep going, and there'll be contemporaneous liquidations or some form of external administration process at the same time. This is often an issue when we're dealing with QBCC here in Queensland for builders whose whether or not they become classified as an excluded individual is impacted by how many insolvency events they've been connected to as a director of a company. One of the other things that I think hasn't been talked about much is that during the restructuring period, shareholders, so you've got your directors and you've got your office holders, but then you've also got shareholders of the company. They can't deal with their shares during that restructuring period without the consent of that small business restructuring practitioner or a court order. So there can be no alteration to the status of the members. Everything's on hold. So that's something that shareholders, and often it's the case that the director is in one form or another a shareholder of the company. Especially for a company of this size, we're talking about smaller businesses, you often have family members or it's a director shareholder. So they need to be advised about these things before they undertake the process, so they're going in with their eyes wide open.
Absolutely. I think also important to note just the distinguishing between how each of these engagements come around. So obviously the director or the directors will be the ones to tip the company into a small business restructuring. That's on them to make that sort of resolution at a board meeting. However, insofar as an ordinary CVL, or creditors voluntary liquidation, and the simplified version of the creditors voluntary liquidation, that will still be a resolution of shareholders. So I often find that the distinguishing appointment mechanisms can sometimes lead to which is the more attractive appointment for the parties involved.
Yeah, that's a good point, definitely. Interesting about that as well, there's the ability, so if there's a resolution for the simplified liquidation procedure, creditors who are holding 25% or more of the value of the creditors in the company can in fact direct the liquidator to transition it back to a full-scale liquidation under the Corporations Act. So again, something that the directors and office holders should be aware of, so that they don't start this process thinking that that's it and they've got complete control moving forward. And there's some discretion. I think the liquidator can transition it as well.
Well, I don't actually think it gets transition status. And again, we're waiting for the regs to clarify, so it's very difficult to figure out how it works. But my understanding, just from the practical perspective, is you would enter into a CVL the same way that you do any other way, and the liquidator actually has 20 days to elect whether or not they will invoke the simplified regime or not. And they need to provide notification of that to all of the shareholders and the members and the creditors, as I understand it. And it's at that point the creditors can say no.
Right.
So if they'll have there obviously will be a decision period, and creditors will come back. And if that 25% come back and say, no, we're not happy with that, and there's reasons that might happen. We can talk about that in another time. But if they say no, then it just keeps trotting along as an ordinary CVL.